Yesterday, we learned about the difference between revocable trusts and irrevocable trusts, as those are the two most common forms of trust that are used in estate planning. For this part two, we're going to follow up on the discussion and dive into revocable trusts a bit more and look at how those are funded. This is a presentation that's primarily for individuals who are looking to implement or update their estate plan or understand more about the process, but this could also be valuable for advisors who want to learn more and attorneys who want to brush up on their knowledge as well. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. Today's episode 210, is all about common estate planning trusts, and this is part two of a multi-part series, and I have no idea how many parts there will be because there's a lot of ways I could take this, especially getting into some uncommon trusts. But as always, this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only. And if you'd like a little bit of an example of what I do and what I provide tailored estate planning and tax education to the financial planning world and the legal world. So if, based on what you hear in this presentation, you'd like to leverage estate planning education to differentiate your firm, practice, organization, or financial institution, you can reach me at griffin.bridgers@gmail.com. Now back to the presentation. So yesterday we talked about a different approach to trust where I looked at the extreme views of how they're perceived based on the sales-driven nature of estate planning and financial planning. And we dove into the big differences between revocable trusts versus irrevocable trusts and some of the purposes that drive the choice of these specific types of trusts. Now, tying it all together, we looked at when the trust is created and how it's created. And I think it's important to note that increasingly, estate planning is using this revocable trust structure, at least during life. But at death, as we learned yesterday, most trusts become irrevocable. The big difference is the source. You can set up a revocable trust document during life, which will create trusts that are irrevocable at your death, or you can use a will to set up trusts that will become irrevocable at your death. Those trusts are known as testamentary trusts. The difference is that revocable trusts can be funded during life, whereas irrevocable trusts through your will, in other words, testamentary trusts, are always going to be funded at your death. Similarly, if your revocable trust creates irrevocable trusts at your death, those will also be funded at the time of your death. So the method of funding will be the focus of today's discussion. Now, before we get into the depth of funding, I want to give you kind of a roadmap too that we're going to look at a will-based estate plan versus a revocable trust-based estate plan. And to get to that point, we have to have some color on funding the revocable trust. Now, one of the biggest misperceptions out there in estate planning is that if you have a will, that's good enough. That gives away all your property and it's a set it and forget it type of solution. You can just do a will and throw it in a drawer and you're done. Well, unfortunately, that's not the case, and it's not for the reason you think, and it's not a statement that's designed to encourage you to get a will or to sell you a will. Instead, what a lot of people don't realize is that there's a certain hierarchy to how assets pass at your death, which will override your will. So even if you have the perfectly drafted will or revocable trusts, there are certain things that will override the terms of your will. First off, some assets that have more than one owner contain certain rights under state law that cause those assets to pass in full or in part to the surviving co-owners. Sometimes this is between spouses, and sometimes it could be between unmarried individuals, depending on the form of title that's used. So some common examples would be joint assets. Those are known as joint tenancy assets. So for example, if you're married, you and your spouse might own a bank account or your residence as joint tenants. And what that means is that if one of you dies, their interest will automatically go to the survivor. So the survivor ends up owning the entire joint asset automatically, regardless of what your will says. It could be the case, depending on the state you're in, that assets could be titled as tenants by the entirety or community property, which may cause the entire asset to pass to the survivor in the case of tenants by the entirety, or it could cause one half of the asset, regardless of titling, to be vested in the name of the survivor if the marriage is terminated by the death of one of you. Now, regardless of the methodology, these transfers will avoid probate, but the issue is these assets have to pass to individuals. So if you're thinking, oh, great, I can avoid a probate by just putting all my assets in joint titling forms, well, that's not ideal because there are certain protections that are inherent in trust that we'll discuss in a later episode. So if you leave everything to individuals, it may not be an effective use of the assets, and it may miss opportunities for protecting those assets or minimizing taxes with respect to those assets. That's a subject for another time, but we have to move down the hierarchy as well. Another layer that kicks in before your will are assets that have a beneficiary designation. So some common examples would be life insurance and retirement plans. Those assets tend to have a contract with a financial institution or an insurance company that says, upon my death, pay this asset automatically to one or more individuals or even entities I might name as beneficiaries. And increasingly, this has always been the case, but it's become more popular, but you can add a beneficiary to a cash or an investment account. This is often known as a pay on death or transfer on death designation, abbreviated as POD or TOD. But either way, if you name a beneficiary, then at your death, that asset is automatically going to pass to that beneficiary, regardless of what your will says. Now, I mentioned that you don't have to just name individuals here, so that's the big difference from joint ownership. With joint ownership, typically, if you're avoiding probate, you have to have individuals in play. But with a beneficiary designation, you could name non-individuals. So for example, if you have a revocable trust, you could name your revocable trust as a beneficiary, which could be a good outcome. And these transfers will avoid probate unless your estate is named as a beneficiary. And that could happen intentionally or it could happen by accident if all the beneficiaries you name are not alive to collect on that asset at your death. So if your estate is a beneficiary, then that asset's going to be subject to probate. If your estate is not a beneficiary, then typically these transfers by beneficiary designation will avoid probate. Then finally, all other assets pass according to your will, or if you don't have a will, there's a set of state laws called intestacy statutes that dictate where your property will go. Any transfers that happen under your will or under state law, the intestacy statutes, will always be subject to probate. So, big picture is that you can avoid probate through joint titling or through beneficiary designations, but any assets you own individually at your death or interest that you own individually at death have to pass through probate if there is no beneficiary designation or joint titling. So, how do we avoid that even for those individually named assets? Well, you have the option to create a revocable trust and take those non-beneficiary, non-joint assets and transfer them to your revocable trust during life. If you do, then those assets are no longer owned by you and thus are no longer subject to probate because they're no longer in your individual name at death. Instead of having a will that tells you where those assets are going to go, you instead have a revocable trust document that tells you where those assets are going to go. And as I mentioned above, you can also make that trust a beneficiary of assets. So for assets where you have that option, it may be better to just name the trust as beneficiary instead of transferring the asset during your life. Now, with that being said, most individuals can choose between an estate plan that's based just on a will or an estate plan that revolves around a revocable trust. Because as I just mentioned, what we saw is that you're going to have a choice of either the will or the revocable trust that dictates where your assets go at your death. Now, if you choose a revocable trust-based estate plan, you're usually going to have a will in place that takes anything you didn't put into your trust during life and transfers it over to your revocable trust at your death, which, as I remind you, at that point the trust becomes irrevocable. Now, this type of will is known as a pour-over will. So if you choose the revocable trust-based estate plan, you still have a will, but it's just a simple will that just names your revocable trust as the sole beneficiary of your estate and of any of your probate assets. Now, there are benefits to the revocable trust-based estate plan. The biggest ones are enhanced privacy and possible probate avoidance, but both of these require some additional homework and are not absolute. The reason probate avoidance is not absolute because even if you do this perfectly, even if you do lifetime transfers, beneficiary designations, so on and so forth, it's important to note that creditors can still compel probate at your death. So if you have no probate estate, the probate estate is what's usually subject to claims of creditors, but creditors can look through that to the revocable trust if they're not getting paid and make claims against that revocable trust for your lifetime debts in a lot of states. And if you don't get around to putting all of your assets into your revocable trust or naming your revocable trust as beneficiary of those assets or separate trusts under the revocable trust as beneficiary, then those assets may not avoid probate either. It's also important to note that privacy is not absolute. A lot of people just take a trust and name it based on their name. So, for example, I'm Griffin Bridgers. I could set up the Griffin Bridgers Revocable Trust. Well, guess what? If somebody finds the title to that, they're going to know that I created a revocable trust, and they're going to want to see it. So, if you use your own individual name as the name of the revocable trust, that's not going to provide a lot of privacy. There's no art or science to that. That's just intuitive. And not only that, you could have, even if you have an anonymous revocable trust with a name that can't be tied to you, you could have lifetime transfers to that trust of things like real estate that could become public record. So privacy is not absolute when you use this revocable trust. Usually it's just a product of avoiding probate if you can avoid it. And even if you do have a streamlined probate, interested parties could still find out about the trust, such as creditors, and may be entitled to receive information. So how do we tie all this together? Well, here's a good visual representation. So we're going to start off. Note that I don't have jointly owned assets on this chart because those jointly owned assets are going to go to the individual joint owners, sometimes in full, sometimes in part. For the parts that don't go to surviving joint owners, those are going to be wrapped up in this first box that says individually owned assets. Anything that you own individually at your death has to go through probate and passes according to the terms of your will. So if those assets are not put into your revocable trust during your life, then what happens is that at your death, they flow through the terms of your pour-over will, as we see in the box below. And that will also name a personal representative or an executor whose job it is to identify and locate and collect those assets and then pay them over to the trustee of your revocable trust. Now, if you have any assets that are beneficiary designated and you name the revocable trust as beneficiary, those assets will be transferred directly to the revocable trust. Those could include things like life insurance, retirement plans, annuities, and sometimes even cash and investment accounts. Now, there's a lot of nuance to retirement plans, especially around the beneficiary designation, and it's not always a good idea to name the revocable trust as the direct beneficiary of retirement plan assets or tax-deferred assets. But that's a subject for another time. Then finally, real estate is a big deal because during life or at death, you have to have deeds that transfer that real estate. So any individually owned real estate has to pass through your pour-over will, and the personal representative has to do a deed that transfers that real estate to the revocable trust. But if you own real estate during your life, you could also go ahead and preemptively put it into the revocable trust. That may be a good idea, especially for real estate located in another state. because you're going to have a probate not only in your home state, but potentially in each state in which you own real estate. So those lifetime transfers for out-of-state real estate by a deed to your revocable trust may be a great idea. In some states, if you don't want to transfer real estate during your life, allow you to do the equivalent of a beneficiary designation. This is known as a beneficiary deed, where you can name a recipient of the property that happens automatically at your death without having to go through the probate process. So if you can do a beneficiary deed, you could also name the revocable trust sometimes as the beneficiary of real estate, depending on state law. Then finally, once everything's into this revocable trust, you have a trustee named to succeed you who would make decisions regarding distributions during your life, or if you're deceased at your death. Now, this kind of ties it all together, but keep in mind too that the revocable trust is revocable just during your life, but at your death, it becomes irrevocable. So any of these transfers happening after your death are permanent and come into the hands of the trustee of the revocable trust, whoever that might be. As always, if you have non-client related questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.